What the bill does, it's not about the merits of abortion. It's not about the value of abortion. About whether or not we're going to pay for it with state funds. If we're going to pay for elective abortions with state funds. And if you remember, about a week ago, we had a hearing on that and put a lot of questions on the table. This is the bill is a follow-up to that past hearing that's on the minutes. I'm going to ask my staff, Jim Pound, to go through the bill and tell us what's in it.
House Bill 363 is an appropriations measure that cuts at least money from the current state spending. In 2011, the Department of Health and Social Services spent more than $250,000 for unnecessary termination of human life. Additionally, they devoted another $250,000 on related services. These are Medicaid funds. Medicaid, according to Black's law, is defined as, if I may read, Mr. Chairman, quote, a form of public assistance sponsored jointly by the federal and state government providing medical aid for people whose income falls below a certain level. Likewise, medical is defined under Black's law, again reading, Mr. Chairman, pertaining, relating of belonging to the study and practice of medicine or the science and art of the investigation, prevention, cure, and alleviation of a disease. Neither legal description indicates anything about life termination or abortion. The question, does HB 363 outlaw Roe? It does not in any way, shape, or form a description. It simply says that the state will no longer pay for an elective procedure. That's money that can be returned to the general fund or used in a more productive Medicaid service. $500,000 may not sound like a lot of money on the grand scheme of Alaska's budget, but applied to the needs of the needy and of Alaskans, it could be money better spent. I appreciate your time, and I'd be glad to answer any questions if you have them.
I have some questions.
Sure.
Thank you, Mr. Chairman. Isn't it true that it's not of you or the witness? Isn't it true that the state Supreme Court is the one who's ruled twice that under our state constitution, we cannot, if we're going to provide pregnancy services and health care, refuse to provide abortion services? If we're publicly funding pregnancy and health services, we have to allow women to have the choice to end a pregnancy. Is that right?
The great question. I went back and I read the decision by Chief Justice Fabe a number of times, and here's a comment. It's in the second paragraph. This case concerns the state's denial of public assistance to eligible women whose health is in danger. It does not concern state payment for elective abortions. And the reason that's significant is that at this point, there is no guidelines in regulations or in state law, either on when a woman's health is in danger or what an elective abortion is. So we have the option of defining those terms.
May I ask another question?
Sure.
Thank you. What happens if I'm a wealthy woman and I would like to have an abortion? I mean, can I just go out and pay for it then, if this bill passes? Would you restrict that right? No state funding?
No, this bill is about Medicaid abortions, and it does not restrict anybody's right to pay for an abortion.
So then you're allowing one group of women to be able to have a choice, but not another.
That is, you're pointing up the basis of the decision is the equal footing, the equal access before the of Medicaid services, and yes, that is the question that we're pushing at, defining just what is a medically necessary abortion, so that that determination can be made for everybody. Because right now, without the guidance, it's been a continual turmoil and confusion in the state. So,
but again, it wouldn't matter if the person can pay for it. So we're treating differing Alaskans different.
No, there's no requirement that we pay for a wealthy person's abortion. This just removes all public funding for abortion. Did you have something to add to that, Jim?
I believe through the Chair, Representative Kutula. the interpretation that I believe the Supremes used at the time was from the Roe decision, which is a strict scrutiny test. That has been overturned by the U.S. Supreme Court. It is now undue burden, and it is a much easier to work with decision. That was in Casey in 1992. And the undue burden clause changes the requirements for the constitutionality of who does and who does not. It does not require Medicaid to pay for it. And in fact, our Medicaid program does not pay for for contraceptives. So therefore, an elective abortion is essentially a form of contraceptive. So under that definition, it is under, if you think about it, it's oops, and it's a form of contraception.
Well, if I might, no one uses abortion as a contraceptive time after time in Alaska. That's not something women like to do. I mean, that's to analogize it to contraception, I think, is really wrong.
Through the Chair, I didn't say it time and time again, but I believe it's quite often used as a form of contraception.
I doubt those statistics heavily. I'm sorry, Mr. Chair. That doesn't sound right at all to me. But.